give you guys information about that shortly. So happy Thursday, guys. Welcome to today's what? Oh, coming up on it. Anatomy of a residential real estate transaction. This discussion today, this is our weekly discussion every Thursday. It is powered by Experts University and the Realtor Association of the Palm Beaches. We do this in collaboration every Thursday for the purposes of bringing bite-sized training and lunch content to realtors to grow your business. At the end of the day, this is all about making sure that you guys feel competent so that you then will feel confident, and then it will increase your compensation. So if you've been on these calls with me before, you know that I always say I love all of you, love to see each and every one of you every Thursday. But at the end of the day, when we jump off this call, I want you guys to go do deals. I want you to go get business. I want you guys to go be great, right? For those who I have not had an opportunity to meet before, my name is Ray Cole Jackson. I'm a South Florida real estate and finance attorney. Originally from Florida, Miami specifically. Went to UF, or if there's any Seminoles in the room. I went to Santa Clara University School of Law in California for my law degree. Beautiful there, beautiful there. And it can get hot there too, actually. Came back home to Miami, where we know it can get ridiculously hot as well, and got my LLM in real property development. That's a specialization for attorneys, but I am also a licensed Florida real estate sales professional. Got my first license in real estate in California, my first real estate license. So yeah. By virtue of my training and love for real estate, I have had the ability to found a number of real estate related companies, including Model Mortgage Experts, which is our mortgage brokerage, Title Experts, which is our title insurance and settlement firm, and then Experts University, which is our training and coaching platform for realtors. We also are super, super, super happy. You should see her in the chat, in the room somewhere amongst everyone. Ms. Jessica Nowak has joined our team. She came in on the title expert side, and I would tell you guys for sure that we must always use people in their highest and best use. And so Jessica came in with a wealth of experience, specifically in real estate. She's a licensed Florida real estate broker herself, a licensed Florida real estate instructor. She is a whiz when it comes to problem solving, systems, coaching, training. I said, you know what? Got a lot of realtors in our community that could use you, Jay. I call her Jay. So Jay is our new community manager for Experts University. You should see her there like I said, in the community, in the room somewhere. It's a lot of you guys. But feel free to reach out to Jessica. Her contact information is there in the chat. You will be hearing from her. Those of you who are already a part of the community, you will be hearing from Jessica as she introduces herself, and then just gets more information about how we can help you guys grow personally and professionally. For those of you who are not a member of Experts University, you found us through the board. Feel free to join us. You join the community by visiting us at expertsuniversity.com. It'll give you a couple instructions. We do have a Facebook community where I do go live in there sometimes, and there's information. This recording, actually, this is day one, will be posted in that community. All the time we're asked for recordings. I teach every week, and some of the classes are very long. And so this recording will be hosted and live in the Experts University community. So if you're not a member, join, and you'll see this recording there. Some other trainings that we have coming up this month, some in collaboration with the board, and some that are powered by our mortgage brokerage. Every Monday, we conduct our Monday sales huddle, powered by Model Mortgage Experts. That is mindset, new money, and market updates. That is the opportunity for you guys to come in. I'm not sure how many of you participate in your brokerages and sales meetings, but sales, and for sure, the real estate culture environment that we're in right now can be challenging. And so the idea of the Monday sales huddle is to reset your mindset. You guys know, if you don't know, you're going to find out that success in this business is going to start with your mindset, right? Your mindset to to learn. That's why you're in the room. Great God, great job. Your mindset to find resolutions, right, to issues, because no deal is going to be the same. But at the end of the day, what I want to make sure that you guys understand is every expert was once an amateur. Every expert was once an amateur. Even with all our brands being named under the experts brand, we were all once amateurs. I was not born an attorney. I was not born a licensed loan originator, right? So on Mondays we come together and we do a quick mindset shift. We discuss ways to go after new money. The market changes, right? We all know interest rates change and inventory and all those different things change. So we discuss that, and then of course market updates, what's going on in the market. So that's on Mondays. Next Thursday is Show Me the Money, how to review the closing and settlement statements. And then the following Thursday is a 3-hour as is contract review course. So these are all the courses that are coming up and trainings that are coming up for the rest of the month. So again, for those of you who are not already on our notification list, feel free to join so that you don't miss any. Today's call is specifically powered by Title Experts. We are talking about the contract to close process, right? So for those of you who have not had an opportunity to work with Title Experts before, we welcome you to the opportunity to work with Title Experts. We do believe that we are the most knowledgeable and efficient title insurance settlement firm in the state of Florida. Some of the features and benefits of working with Title Experts include we are an attorney managed firm. You'll learn that not every closing agent is an attorney. We are managed by attorneys. We provide a dedicated closing team. Transaction coordination services are available, regular status updates, and then again, training such as the one you're participating in today. On the screen, you see how you can work with us. Contracts at titleexperts.com is where new contracts are sent. General questions are sent to closings at titleexperts.com. And you can always reach us at 561-510-2294. All right. All right. So let's get into today's discussion. Anatomy of a residential real estate transaction. I know we got a couple commercial people in the room. I met some of you guys in the commercial arena. Today we're talking residential, right? So a lot of familiar faces, but tell me really quickly in the chat, how many years have you been in the real estate business? How many years in the chat? Talk back to me today. Have you been in the real estate business? 4 months. Christine, love it. Welcome. 1 year and a half. Okay. 8 years, 1 year, 1 year. 30 plus years, Karen. All right. Donna just started a month ago. Woo! Welcome. What a time to start with us. We're happy to have you. 18 and a half years. Awesome, awesome. Is this the first time that you've taken a class on this topic? And then in the chat, what do you most hope to learn and master today? First time. All right, Victoria, first time. What brought you here? You're like, I hope she answers this question today. Okay, Jasmine, first time. What if you say, I hope she answers this question specifically today? Just have a better understanding of contract to close process. Okay. Timeline. Oh, yes, George. Good job. Better understanding of the contract. The order from start to finish. Nothing specific. She's an expert. Okay. We service all of Florida. All of Florida. We actually have one of our satellite offices in Winter Park. What part of Central Florida? Orlando area or Tampa? Near Lake Nona. Oh, I love Lake Nona. I love Lake Nona. Wink, wink. I love Lake Nona. All right. all of that area where most contracts gives delay. Okay. All of that we're going to discuss today for sure. So anatomy, our discussion today is going to be, and many of you hit it on the head already, executing the agreed upon terms of the purchase and sale agreement, right? So let's say, for example, you've taken the contract class, you're like, okay, I'm good. I understand the terms. I understand all these different terms. I believe I've everything. I remember, Ray Cole, you said, don't leave any blanks. I made sure that everything is initialed and signed, all the pages, all the writers are attached. Now what? And this class was literally written when one of my realtors, and this was a number of years ago, but he had got a nice sizable deal back, oh my gosh, 5-6 years ago, but it was a $400,000 deal, $450,000 deal, which in today's numbers will probably more like 750. And he was like, he had a contract executed. He's like, now what, Ray Cole? And I'm like, oh boy, like I need to write a class. That's what, because this is a nice deal. And again, but every expert was once an amateur. So this class was born out of that. I'm under contract. Now what? That's exactly what he said to me. I'm under contract. Now what? So we're going to talk about how you manage the milestones and common tasks associated with maneuvering from contract to close. You're under contract. Now what? Additionally, I believe I saw this in the chat, some of the common missteps that occur in the contract to close process that can be disastrous to the transaction. I know Karen says she's been in business for 30 years. I saw 18 years. And I'm sure they can tell you every deal is different. There are some fundamentals that you should know. And then there are just literally some hot spots. I taught a class, I think a week ago or so, that there are some hot spots. There's some hot spots in the contract that you just must know. Hopefully after today and taking a couple more classes with me, you won't commit some of these missteps, right? But at the end of today's conversation, you will have a comprehensive understanding of how to effectively manage and execute upon the agreed upon contract terms. You've agreed to these things. Now, how do we execute them? A timeline abstract framework for tracking critical tasks and deadlines. And then you're going to become, again, aware, like I said, of the common missteps that compromise a successful transaction. For the new agents, the experienced agents will agree. Generally, you have the same steps. You have the same milestones. So starting from where we are right now, I want you to create a framework within yourself that these are the same steps. I don't share the slides, so you can do screenshots. Again, the recording will be posted in the community. So there you go. You know what I will do? I do have a handout for this class, and I'll post that in the community as well. All right. Jay, don't let me forget. We need to post the handout in the form section of the Facebook community. All right. Every transaction for the most part has the same milestones for the most part. Now, obviously, if you attach riders that add some additional steps, cash versus finance, have some things. If you waive an inspection period, we're not doing that as much anymore. Waiving appraisals, then obviously you're not going to hit that step. But we're going to review a finance transaction in general. And those milestones generally are making the escrow deposit, conducting the inspection, making a loan application, appraisal, getting a loan approval, the association application if relevant or if applicable, the association approval, title search, lien search, estoppel, and survey. I made those a different color because that's part of the closing process. You're not responsible for driving those, but that is a milestone. And then we jump back into settlement statement review, final walkthrough, and closing day. These are essentially the major milestones from a contractual standpoint in your contract to close process, right? So George mentioned this, and this is very important, and we start here. When we talk about managing timelines, the fundamental concept that you must have committed to memory. And there's not a lot of things I'm going to tell you that you have to have committed to memory. But what you must have committed to memory is how to compute time periods. Because in order for you to effectively manage milestones and deadlines, you have to know how to properly compute time periods, right? So anytime you take a class, certainly my classes, and probably most other classes, the context of the class is going to be the FAR bar as is residential contract for sale and purchase. For the new agents in the room, the reason why I make that point specifically is because we have about 2 standard residential purchase and sale contracts. We have the FAR bar as is, which is used in 99% of transactions. And then we have the standard contract for residential sale and purchase. So I'm not going to go too far into that, but understand that that's why I made the distinction between to state that we're discussing the FAR bar as is residential contract for sale and purchase, right? So in that contract, our time periods are calculated using calendar days, what we describe as calendar days, right? So in understanding that we use calendar days, to effectively calculate time, you must confirm the contract effective date. That's the starting point. What is our effective date, right? On page 1, paragraph 3B is the definition of effective date. It says specifically, the effective date of this contract shall be the date when the last one of the buyer and seller has signed or initialed and delivered this offer or final counter offer. Again, let's go back to our hypothetical. We made an offer was accepted, we're under contract, now what? First thing is, what is my effective date? Because everything that I have to do after this is measured against my effective date, right? And the contract again says in paragraph 3B, the effective date of this contract is when the last one of the buyer and seller has signed or initialed and delivered this offer or final counter offer. That is my effective date. Just listen. Someone said, I'm lost already, Ray Cole. Just listen. I promise it'll be clear as mud in a second. When counting, the effective date is considered day 0. Okay? The effective date is day 0 when you're counting. So understanding, does that include the addenda? So that's a good question. If you have if you made an offer, if you guys are negotiating an offer and it is clear that there should be addenda attached to create a full contract, then once you get that addenda, then now you have a fully executed contract. But if in further negotiations you guys decide, oh, we need an addenda to extend the inspection period, you don't move your effective date to the date that addenda was attached to the contract. It's still going to be your initial contract date, if that answers your question. Perfect. All right. So let's practice calculating deadlines. We start here because once we get this down, it's like medicine. Once we get this down, everything else will run very, very smoothly, right? So remember the definition of the effective date. The effective date is the date when the last of the buyer and or seller has signed and delivered to the other party. So let's say our effective date is Thursday, April 4th. Take your phones, roll your calendars back to 2019. Roll your calendars back to 2019 and give me in the chat the date that the first escrow deposit is due, if it's due within 2 days. So a question in the chat, they send back signed offer, but it's missing the signed addendum. Would the contract be considered executed? No. Great question, Hannah. So if the offer clearly contemplates, you have checked off that there's let's say it's a short sale rider. Yeah, let's say short sale. And the short sale rider was not attached. You don't have a fully executed contract. You don't have a fully executed contract because there's a rider missing. Let's say there was we're gonna say HOA addendum. Checked off, clearly should have been included, it was left off. you don't have a fully executed contract until the HOA addendum is signed to complete the contract. But let's say you didn't know there was HOA, and believe it or not, I've had that situation before. You found out there was an HOA once it got to title, and title said, hey, there's an estoppel that's needed, and then you attach it, then that doesn't change the effective date. All right, so first escrow deposit due date. If it's due within 2 days of April 4th, when is it due? Due within 2 days of April 4th, when is it due? Drop it in the chat. Due within 2 days of April 4th, when is it due? First escrow deposit in the chat. Due within 2 days of April 4th, 2019. When is the escrow deposit due? Okay, I see the 8th, I see the 6th, I see the 28th.
The 8th.
On something. Okay. Karen says the 8th. Gotcha. Oscar says the 8th. Gotcha. And when is the second escrow deposit due? When is the second escrow deposit due? Second escrow deposit is due within 10 days of the effective date. Within 10 days of the effective date. The effective date was April 4th, 2019.
On the 15th of April.
All right, we got the 15th. Got the 15th. D, I see your question. 1 second. I see the 15th. I see the 16th. I see the 18th, the 18th. Here's your answers. So, very good teaching points in the chat. So, number 1, the effective date is April 4th, 2019. The reason why the first escrow deposit is due on April 8th, because 4/6 is a Saturday. So D, that answers your question. We don't include Saturday for the escrow deposit. I'm gonna go into that a little bit further. The second escrow deposit is due on Monday, April 15th, because April 13th is a Saturday. And then so on and so forth. I saw in the chat the 18th. That's a good teaching point. It's going to be from the effective date of the contract, not the date the last escrow deposit was made. It's from the effective date of the contract, not unless you write it that way. But if it's based on how the contract is written, standard language is going to be from the effective date of the contract. It's still measuring from the effective date of the contract. I see the Sunday count. We're going to get to that just shortly. So beware of deadlines that end or occur on a Saturday, Sunday, or national legal public holiday, or a day that a national legal public holiday is observed. So that, what we just did was intentional. What we just did was intentional. It's 2019, I should roll it forward, but that's how long I've been teaching this class. Actually before then, right? So here's where that comes from. Survey deadline for sure, it's actually in here. Paragraph F of the contract, standard F, which is the standard definitions section of your contract. The standard definition section of your contract provides you with the definition of time. And this is where you essentially get all of your rules regarding how to calculate the effective date and how to calculate deadlines. So we review paragraph 3B, which is where you define your effective date. And now we're reviewing paragraph F, which is your definition of time. Now, one point I want to make with regards to the effective date, I want to be clear what effective date means. It says when the last of the buyer and or seller has signed and delivered. We can't gloss over that. So for new agents, your effective delivery requires signature. It requires signature and delivery. Effective date requires signature and delivery. So if we have I see your comment in the chat, Andrew. I'm not sure I'm clear on what the discussion is, but I'll get back to it in a second. If we have our contract was executed on April 2nd, right? But I don't return the contract, it's not delivered until April 5th, the effective date is April 5th. Because it requires signature and delivery. Signature and delivery. And for the new agents and even experienced agents, unfortunately, there's nowhere in the contract for us to know what the effective date is. But we're going to talk about that in a second. But just know that, first of all, effective date is signature and delivery. Okay? Carmen's question is, when is the second deposit due? How many days from the effective date? It's whatever date, it's whatever you put in the contract. So whatever date you put in the contract, right? And we actually have a screenshot. I put 10 days from the effective date. 10 days, I believe it was, from the effective date. But remember, we're using 2019, not 2023. Okay? So let's look at paragraph F really quickly. Time is of the essence in this contract. I'm going to read this verbatim. Calendar days based on where the property is located shall be used in computing time periods. That's where we get the calendar days from. Other than time for acceptance and effective date, other than those two deadlines, as set forth in paragraph 3, any other time periods provided for or dates specified in the contract, whether pre-printed, handwritten, typewritten, or inserted herein, which shall end or occur on a Saturday, Sunday, national legal public holiday as defined in the U.S. Code, or a day on which a national legal public holiday is observed because it fell on a Saturday or Sunday, shall extend to the next calendar day, which is not a Saturday, Sunday, national legal public holiday, or a day on which a national legal public holiday is observed. Alphabet soup. Alphabet soup. But you must read it. So let's go through this paragraph concept by concept. Number 1, it says time is of the essence. The term time is of the essence means that deadlines and time periods expressed in the contract are strict. There are no built-in grace periods. Failure to timely perform an obligation required under the contract is a default unless an extension is granted, period. All right. I was on a call one time and the agent was like, well, what about if they're sick? Well, someone needs to let the other party know that deadline did not change, right? That is not a force majeure. That's a whole nother conversation, okay? Calendar days. When you hear that the FAR bar as is calculated using calendar days, that's what we saw in paragraph F. That's where that comes from. This means that every day of the week is counted when computing time periods. It means that you do not skip weekends or holidays when counting calendar days. When you're getting to your deadline, don't say Monday, Tuesday, Wednesday, Thursday, Friday, ooh, Saturday, Sunday, and then go back. No. You count every single day. Now, if that day ends, if your deadline ends on a Saturday, Sunday, or national legal public holiday, a day holiday is observed on, then we have a different conversation. But for the purposes of getting to your deadline date, don't skip any day in that timeline, okay? And then remember, the effective date is day 0 when counting, not day 1, okay? Last point of clarity, it specifically says, other than deadline for time of acceptance of buyer's offer or the contract effective date, every other deadline will be extended to the next calendar day, not the next business day, the next calendar day that is not a Saturday, Sunday, national legal public holiday, or a day that a national legal public holiday is observed. What is that or a day that a national legal public holiday is observed means, Ray Cole? So let's say, for example, 4th of July. Did it happen this year? No, last year, I believe it was. 4th of July fell on a Sunday. And so it was observed on a Monday. That's a day, Monday is a day that a national legal public holiday is observed, and therefore offices were closed, banks were closed. And so that next day, if the escrow deposit was due on, let's say the escrow deposit was due on the 3rd. The 3rd was a Saturday. The next day was a Sunday. That's the 4th. The next day was the 5th, but it was a day that a national legal public holiday was observed. So now that escrow deposit deadline rolled forward to the Tuesday. Does that make sense? So you roll forward to the day that is not a Saturday, Sunday, or national legal public holiday, or a day that a national legal public holiday is observed. That's for all deadlines except for deadline for acceptance of buyer's offer or the effective date. Hypothetical that I always use. Let's say, for example, we made an offer. I have the listing, Karen has the buyer, $7 million listing. Karen's buyer makes an offer on say she makes an offer on Friday, and Karen's buyer is vegan. So she cares nothing about the fact that on July 4th, there's going to be a ton of hot dogs, hamburgers, and my client is a carnivore. Her deadline for acceptance was 2 days from what would we say, the 2nd? Right? So that means she wanted to hear back by July 4th. What is the deadline for my seller to accept Karen's buyer's offer? Drop it in the chat. Offer made on the 2nd. She needed to hear back within 2 days of the offer being made. What is the deadline? July 2nd. Offer made July 2nd. Buyer wants to hear back within 2 days. Buyer wants to hear back within, exactly. It's July 4th. Because it does not move. Those are the 2 dates that do not move. Deadline for acceptance of the offer and the effective date. Let's say it's the other way around. Let's say Karen's buyer made the offer. My buyer is still a carnivore, and he knows that he does not want to be bothered with this whole offer and acceptance and negotiation thing on his July 4th holiday, his favorite holiday of the year. And so he made sure to sign it on Saturday the 3rd, got it back to me. I love July 4th. I love fireworks. So I got it back to Karen on July 4th. What is the effective date? My seller signed it. He signed it on Saturday the 3rd, July 3rd. What is the effective date? I made sure to get it right over to Karen the next day. What is the effective date of the contract? He signed it on July 3rd. My seller signed it on July 3rd. Let me see it in the chat. You said delivery date. You're right, yeah. Wait, did someone say the 5th? Uh-oh. Did I get someone again? No. No. So make sure we get this concept. So delivered on the 4th, she said, so it's the 5th. Deadline for acceptance and effective date are 2 days that do not change based on it being a Saturday, Sunday, holiday, or a day on which a holiday is observed. Nope. 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 Other than time for acceptance or effective date, those are the two. No, it's July 4th. It's July 4th. He signed on the 3rd. I kept saying the 3rd because I wanted to throw you guys off. He signed on the 3rd, but I got it back to Karen on the 4th. Signature and delivery was effectuated on the 4th. So our effective date is the 4th. And that date does not move because it was a holiday. D is so entertained by this. And the deadline is 11:59. It is no longer 4:59 p.m. The old contract says 4:59. So for my veteran agents, it is not 4:59. It is 11:59 p.m. All right. The hard part is over. I know someone's like, oh my God, I did not sign up for this. Quick question. Escrow deposit was sent on the last day, but it didn't appear in the escrow account until the next day. Is it considered a breach of contract? Nope. It was sent. depends on how was it wired, right? If it was wired, for sure, there's proof that it was sent. I would, and it is not even worth getting into the technicalities of that. That's a whole nother class on starting talking about who breached and not. Like, that's not worth it. Sent it. Let's get to the closing table. So, understanding time. Consider creating calendar appointment notifications for contract deadlines. It depending upon what your setup is, what your team structure is. If you are a solo agent, you don't have a transaction coordinator, you definitely need a calendaring system. So, pro agent tip, I hinted at this a little bit of a few minutes ago. Because the contract does not indicate anywhere, does not provide any area for you to confirm the effective date, pro agent tip: always confirm the effective date of the contract in your initial email upon delivery or receipt of the fully executed contract. Going back to our hypothetical, I love July 4th. I just shot the email over to Karen and ran off to do fireworks. Didn't even say anything. Hey, Karen, here you go. Contract signed. Karen is a pro agent. Karen says, great. Confirming receipt, Ray Cole. Our effective date is July 4th. I know you love, the 4th of July. Go enjoy your fireworks. She confirmed the effective date because we're best friends now, right? We're under contract, $7 million deal. But when we get down the line and something we don't agree on the effective date, we don't agree about a deadline. Are there ways to figure that out? Sure, but why do we have to be Inspector Gadget? Let's just be clarity, right? Let's be professional and have the date documented. Now, if you work with a transaction coordinator, that should be the first line in their email to title the cooperating agent, your clients, right? The lender if you're on the buyer side, right? So once a contract is executed, the key dates, the milestone dates, should be laid out in a timeline so that we all know what are our marching orders, okay? So if you don't have a transaction coordinator, you should do this yourself. If you do have a transaction coordinator, they should definitely be doing this on your behalf. In that handout, I saw the question in the chat. What I mentioned was, if you sign up for Experts University, we have a community on Facebook where this recording will be posted along with the handout, and the handout includes this sheet. Okay. The last thing I'll tell you about this concept is, even in making an offer and accepting an offer, you should run it through this framework, because sometimes the dates are in different places. It's a 12-page contract. And so it may sound good, but once you do the date abstract, you're like, wait a minute. They have until 3 days before closing to get HOA approval. And they can cancel if they don't get their HOA approval. Do you want that? Do you want to be finding out about that at that point? Probably not. So that's another good practice for using the date abstract, even when you're making and reviewing an offer to be accepted. All right. So time, that took us 40 minutes. Oh my God. But the rest of it, we're going to move through. But that's one of the most important sections. That's a class all by itself. You mess that up and everything just breaks loose. Okay. So escrow deposit. Here's what you should know. New agents, know that the escrow agent can be different from the closing agent. For example, sometimes not just buyers, but brokers will decide that they want to hold the escrow deposit on behalf of their buyers, although there will be a separate entity that is conducting the closing. Okay. Here's what's important to each party. We're going to go over what's important to each party at each juncture, at each milestone. For the seller, you want to ensure that the escrow letter is received. Right? You don't want to just assume that the escrow deposit was made. You want to ensure that you receive an escrow letter. Understand that the closing agent, the escrow agent, is not obligated to enforce the escrow deposit being made. They only receive it and confirm receipt. But if an escrow deposit is not made, they'll reach out and say, hey, did you send it? But they're not, you must send it. Your deadline was 3 days ago. No, that's not their capacity, right? If you have an attorney representing you, then that's a different discussion. For the buyer, they want to ensure that they don't miss this deadline. As Aaron mentioned, it is a breach of contract to miss the deadline to make your escrow deposit. And then also, if this deposit is being wired, You as an agent, you want to make sure that the wire instructions are sent directly to the buyer by the escrow agent. Do not pass wire instructions. They must come from the escrow agent. Guys, wire fraud is still very real, very prevalent, and it's happening in multiple different ways. So just make sure you don't mistakenly cause confusion for your clients. The next step generally after the escrow deposit is the inspection period. You want to make sure that if there are any agreements regarding what's identified during the inspection, maybe for some repairs or credits or something, make sure that that is signed, that is in writing and signed by the buyer and seller before expiration of the inspection period. Before expiration of the inspection period. Literally, guys, it's not good business. But if you get past the inspection period and you say, hey, you agreed to give us a $5,000 credit, but it's not in writing, guess what? You don't have a $5,000 credit. It's not good business, but you have gone past the inspection period. You've gone past the period when the buyer can cancel for any reason whatsoever. That's the other concept that I want you guys to make sure you understand. During the inspection period, unless you carve out some exclusion, the buyer can cancel for any reason whatsoever. Right? They're like, you know what? Say the buyer's an agent. Inspection deadline is Thursday. They're like, no, Ray Cole teaches on Thursday. Cancel. Sorry, I'm not missing her class. Yeah, that's what it is. You can cancel for any reason. Pro agent tip. Provide multiple options for a property inspector and have the buyer decide who they'll hire. Property inspections, they don't happen all the time, but when it comes up that there was something that the property inspector could have, should have, or would have identified, you don't want them to say, oh, and that's, you just wanted to close. That's the person that you referred. So have them select their own inspector. Generally, once you get past the inspection period, now we're talking about financing. Where's, show me the money. Show me the money. What are we doing, right? Paragraph 8 is your financing clause, essentially. Cash deals. 8A, no financing. It provides that the buyer will pay cash for the purchase and the sale is not contingent upon financing. We understand that contingent means finance that the buyer's obligation to proceed with the transaction is dependent upon them obtaining financing. If you select 8A, there is no financing contingency. This deal will not be canceled because you're not able to obtain financing. Oh, however, notwithstanding this, the buyer is not precluded from seeking financing just because they selected 8A, right? If the buyer does seek financing, however, their obligations under the contract will not be avoided if financing is not approved, right? So you can't say, oh, I'm purchasing cash and then turn around and say, I'm financing. Oh, I didn't get approved. I need to cancel. No, that's not how it works, right? Now, let's say the buyer is purchasing with a loan. What's the milestone you need to be aware of? Loan application, that's a no-brainer, I hope. I hope none of you guys are even working with a buyer who has not obtained a pre-approval. In order to obtain a pre-approval, they should have made an application. So we're just going to deal with the loan approval deadline, right? When they're making an offer, they get a pre-approval. Pre-approval is examining the person. I want you guys, we teach a class, Clear to Close, where we talk about the mortgage financing and underwriting process. Understand that when a lender is underwriting a file to approve lending, they're looking at the person and the property. The person and the property. For the pre-approval, they should have done about at least a 75% examination of the person. A better lender would have done 100% of examination of the person, and now they're just waiting for a property, right? They're waiting to get the info. They're waiting for a contract. They're waiting to get a contract for a property to have an appraisal conducted, inspection, title clear, to get your full loan approval and clear to close. Make sense? All right. So the loan approval deadline is the date by which the buyer must receive from the lender a determination of the buyer's loan approval status. The loan approval deadline is the deadline by which the buyer needs to be finding out from their lender whether or not they're approved, not necessarily to clear to close. Because even with the loan approval, there's always going to be some trailing conditions like, last verification of income. and employment, like during COVID, making sure you still had a job, right? So there's some minor trailing conditions for the clear to close, but the approval itself, there's a deadline for that, right? And then starting at line 111, I think I want to answer your question right now, Seema. This is the answer to your question, actually. Starting at line 111, the contract provides that the buyer must notify the seller of their loan approval status and intentions with regards to proceeding with the transaction. Must notify the seller in writing. Must notify the seller in writing. That starts at line 111 of whether or not they were approved. What are your intentions? And now that's going to be either I'm approved, great, see you at the closing table. Oh shucks, I was denied. Might be related to the property. The borrower themselves might have been fantastic. Maybe there was an issue with the property. Or maybe no approval decision has been made. Maybe the buyer's dragging their feet with getting in some documents that they needed. Either way, by the loan approval deadline, it must be in writing. Email is sufficient. Email is sufficient. You need to either let the seller know you've been approved in your proceeding, you've been denied, you need to cancel, you have no approval yet, but my lender is Superman, so I'm going to proceed, right? That's what you're looking for. If the buyer does not receive a loan approval by the deadline and they do not cancel the contract and they still proceed after the loan approval deadline, their escrow deposit is at risk. So for new agents, I want you to understand that the loan approval deadline is what I call the point of no return. Unless you have other contingencies built into the contract, once your buyer gets past the loan approval deadline, you're locked in. There's no canceling concerning financing, right? Sade's question, at what point can you ask for an extension? You should be asking for an extension before the loan approval deadline, right? And that's the next answer. The next slide, rather. The best course of action for a buyer that has not received the loan approval by the deadline is to negotiate an extension of the loan approval deadline and the closing date. I usually throw in the closing date as well, because generally, if the lender has not gotten the loan approval by that date, they're likely not going to be ready to close by your initial contract close date. If you can't get anything but an extension of the loan approval deadline, take it, I guess, but you should at least have a conversation about extending both. All right. Within paragraph 8, there is an option for the seller to request that they be kept fully informed. Now, the reason why I put fully informed in red is because literally, if you review the contract, it says that the seller can be looped in on everything. Application, underwriting, conditions, property inspection, everything, right? The last point I want to make, and this comes up in the, again, in the clear to close class, a conditional loan approval. That's what you're looking for. That's how all of them are titled, conditional loan approval, because there's some trailing information that they need. Some lenders have more information that they're looking for than others. But I want you guys to understand that just because that loan approval says conditional does not mean that you can cancel the contract after the loan approval deadline and get the buyer's escrow deposit back. Because the loan approval is titled conditional does not make it a new contingency to the contract. Okay? All right. Property appraisal completion, based on the way the contract was updated in 21. If the loan is going to be contingent upon an appraisal, that must also be completed by the loan approval deadline. You no longer can you wait. There was a gray area in the contract where it was a little gray, and people were getting their appraisals done after the loan approval deadline, saying, "Oh, the property doesn't appraise, I must cancel." Contract is very clear now. You must have that done during the loan approval deadline. What will you do if the property doesn't appraise? Cancel the contract, reduce the price, the buyer pays the difference, contest the appraisal. It's up to you guys. There's no right answer. But just know that you should have in mind, if this property does not appraise, what am I going, what are my options? What should I do? What action should I take as the buyer or the seller? All right. At the loan approval juncture, what will the seller do if the initial loan approval deadline is not met? We just talked about this. Are they going to cancel the contract, say, no, I'm not giving you an extension? Are they going to extend but require an additional earnest money deposit from the buyer? Will they start now accepting backup offers? There's a whole host of options the seller has in the event the buyer does not meet their loan approval deadline. At this juncture, what's important for the buyer is, as we discussed earlier, they must be vigilant about meeting this deadline. And if an extension is needed, request it in advance and document the terms in a fully executed addendum before the deadline. Do not wait until the day of the loan approval day, because now you're on the defensive versus the offensive, right? So keep in constant communication with the loan officer for loan approval status. Association approval, nothing major there, except make sure you apply as soon as possible, because some associations take longer than others. Are you supposed to let the buyer know you are accepting backup offers? Yes. Then there's an addendum for that. The boundary survey, someone asked about the deadline. The contract says that paragraph D is line 181. 5 days prior to closing, the buyer may obtain a property survey. Someone asked this question. 5 days prior to closing, right? In a cash deal, the buyer may choose to not order a survey. That is their option. But if it's finance, most lenders are going to require it. With regards to ordering the survey, you don't want to wait too late, but you also don't want the survey ordered too soon. So you may want to request to the closing agent not to order the boundary survey until after the inspection period. If for any reason you must cancel. We're getting into the title milestone. So we just talked about the survey. Title commitment. Seller must convey clear and marketable title to the buyer, obviously. I would suggest that you review the title commitment when it's issued by the closing agent to acquaint yourself with any title matters, so that you will know what the title agent is going to be working on. After you've seen enough of them, you'll know when something is like, ooh, this is asking for a corrective deed from 2 owners ago. That's scary. Correct. No survey is required for a condo. All right. Lien and permit search, what do you need to know? Sellers are not required to close out open permits. Unrecorded code violations, that's in the contract. They're not required. They're only required to cooperate with the buyer's efforts to close out open permits and unrecorded code violations. For that reason, in the additional terms section of the contract, buyer's agents generally include seller will be responsible for closing out all open permits and code violations prior to closing at seller's expense. That's additional term language. So you always include that, right? If you represent the buyer, if you represent the seller, you're like, what are you talking about? Seller's disclosure. A standalone seller's disclosure is not required. You can negotiate in the contract when you make the offer that the seller will execute a standalone seller's disclosure, but pursuant with regards to the language that is in the contract itself, the seller is only required to disclose to the buyer known facts regarding the condition of the property that materially affect the value of the property but are not readily observable. What does that mean? This table behind me. Let's say, for example, I'm the seller. I know that there is a massive hole in the floor under this table, but I've covered it with a rug and chairs and a whole table. What inspector is going to move that around? Oh, and by the way, your buyer loved this table and rug, so we negotiated that it'll be left in the property. That's not, I need to disclose that, right? And if you came to the listing appointment, Andrew, and your pen rolled under the table, and I said, whoa, Andrew, don't crawl under there. Woo, you might fall through. You need to disclose it as well. So both the seller and the agent, if the agent is knowledgeable regarding matters that will materially affect the value of the property but are not readily observable, meaning just a regular inspector is not going to catch it, you got to disclose that. Okay. Title commitment is responsibility of the title company. Agents don't clearly follow the title commitment. Agents don't follow the title. You don't have to follow the title commitment. You want to be knowledgeable regarding how to review a title commitment. You want to at least be knowledgeable of that information. Paragraph 6, occupancy and possession. The one thing I want to point out here, if you know that the property has tenants, you need to select 6B, and you need to make sure, yes, God, need that schedule in front of me. I think it's the next class is it actually might be in November though, Andrew. But yes, I definitely teach a class on that. If the property, but sign up for the community, and you'll get the email. Next month, we're teaching a whole series on representing the buyer, which includes getting the buyer brokerage agreement signed. You know, you guys know about all the litigation that's going on about your commission as a buyer's agent. So next month, we're doing a whole talk about representing a framework around best practices and representing buyers. And so we'll be back doing some of the other classes in November. Okay, so paragraph 6, occupancy and possession. You're welcome. Thanks for asking. Again, make sure that paragraph 6B is checked. Make sure that if you represent the seller, that you get the leases over to the buyer. If you represent the buyer, make sure the buyer reviews the leases, because when if they proceed with closing on that property, they're going to step into the shoes of the seller, and they have to abide by whatever terms are in that lease agreement. I always tell you guys, for example, what if I'm like, Mother Teresa, I own a fourplex. Yeah, I collect $3,000 a month in rent on 1 bedroom, 1 bath, but I also agree that they don't have to pay for lights, water. They get a $1,000 stipend to Amazon and Whole Foods because I love Jeff Bezos every month. Excuse me? I'm not doing that. Well, if you purchase the property, that's what you're doing, right? So review the leases, and if you don't agree with those terms, then you need to cancel the contract, right? If you say, "Oh, I'm Mother Teresa number 3," like I agree with you. I will pay for lights, water, $1,000 stipend to Amazon and Whole Foods every month. We're good. Like I never thought I'd find another person like me. Great. Now you need to get an estoppel to the closing agent to make sure that any rents that have been collected, security deposits that have been collected, that there is a proration that is included on the settlement statement for your buyer. Because when those tenants move out, they're looking for their security deposit still, and they can't walk away with the seller. I mean, it can, but now your buyer's coming up with it, okay? We're going to be a few minutes behind, but we're going to push through. Well, we're at final walkthrough, so we're not too far. Final walkthrough. We've gotten through all these pieces of the transaction. Here's what's important. You want to confirm that the property has been maintained in its as-is condition, that all of the items of personal property remain in the property that should have remained, and the buyer is entitled to a pre-closing walkthrough on the day before or even the day of closing. I suggest the day of closing. I believe the walls have ears. You guys heard me say this before. I think that's all of a sudden pipes break, ACs break down, squatters, appliances grow legs, all types of things happen. You should not inspect a property. You should not conduct a walkthrough days before. I've heard that before and I almost fell out of my chair. Like, what? As close the day of closing. Yeah, things happen. Right? And again, except for ordinary wear and tear, the seller is required to maintain the property in its as-is condition. That includes pool should still be blue, grass should still be maintained, right? The pool should not look the lawn should not look like Jurassic Park, and the pool be just as green as the grass. Like no. It needs to be the same, right? Getting to the closing table, settlement statement. And there's a class on this next week. We're not going to go into, very, very, very far into detail on this topic. This class is next week, how to review the settlement statements. But for the purpose of today's discussion, Paragraph 9 is where we allocate closing costs to the buyer and the seller. Paragraph 9. This is paragraph 9 of your contract. You have 9A and 9B. 9A is telling you the costs that are associated with the seller. 9B is telling you the costs that are associated with the buyer, that are the responsibility of the buyer. For some of the closing costs, the party that is responsible for that cost is based on which option is selected under paragraph 9C. Go with me. Don't get concerned. Someone's like, this is too much information. Paragraph 9C. When you look at paragraph 9A and B, those that you see, and I have them circled in red, it says if 9C1 is checked, if 9C3 is checked, if 9C1 or 3 is checked. Like, you're like, what in the world are you talking about? Those are the closing costs that move around, as I call it. They're going to be, whether they belong to the buyer or the seller is determined upon which option you select in paragraph 9C. Okay? Those 4 costs, actually 3 costs that move around, are the title search, the lien search, and the owner's policy, the owner's title insurance policy. Those are the 3 costs that will have that indication beside it here on paragraph 9. I have a chart coming up for you guys, so don't be concerned about trying to write all this down. So 9C1, 9C2, 9C3, right? Also, what is determined by which option you select under 9C1, 2, or 3 is who's the closing agent, right? So those are 4 pieces of information that move around based upon whether you select 9C1, 9C2, or 9C3. And you guys selected this when you made the offer and went under contract. Now, for the new agent, someone's saying, well, how do I know which one do I select? 9C1, 9C2, or 9C3? That's customary. It's a negotiated term. But what you see on the screen is what's customary. Customarily, in the counties that you see in what I call Title Experts Gold, are the counties where the buyer generally selects the closing agent and is responsible for paying for the title search, lien search, owner's policy. All 4 of these features are on the buyer side. In the counties that are what I describe as title or that are white, they're counties where the seller is responsible for those 4 features: selecting the closing agent, title search, lien search, and owner's policy. In the counties that are in gray, those are your Miami-Dade, Broward regional provision counties, where I call it split the baby. Okay, this is also in that handout. Just follow me. Last 5 minutes. So the specific costs associated with the, if you select 9C1, the seller is going to be responsible for, and put 9C1 in front of you, the seller is going to be responsible for all 4 features. If you select 9C2 when you went under contract, the buyer is responsible for selecting the closing agent, paying for the title search, the lien search, and their owner's policy. If you guys selected 9C3, what I call split the baby, the buyer is designating the closing agent, paying for the owner's policy, the seller is paying for the title search and the lien search. Okay? Here is a table that lays out all of those closing costs in paragraph 9 and who's responsible based upon which paragraph is selected. This is 9C1. The seller is selecting the closing agent, and they're responsible for the doc stamps, association estoppel, owner's policy, title search, lien search, other costs to cure title. Paragraph 11, cost to maintain and repair. Remember we talked about the pool and the grass? If they do allow the property to go into shambles and and you have to pay for it to get back to its as is condition, seller's responsible for that. And then FERPTA filing fees. Okay. Buyer's responsible for what you see there. 9C2, poof, everything shifts to the buyer side. Buyer selecting the closing agent, paying for the owner's policy, title search, lien search. All the other costs, the costs you see in black, those are pretty static. They stay where they are. And then 9C3, what I call split the baby, the buyer is selecting the closing agent, paying for the owner's policy, seller's paying for the title search and lien search, the cost that you see in the black, they're staying where you see them. So that's reviewing the settlement statement, right? Closing day preparation. We've gotten all the way through settlement. Can I go back to slide to B? Okay. Which one? Oh, C2, measurement. And 3. Closing day. All right. So we've gotten through all of those steps. You're welcome. We've gotten through all of those steps. We've matched them. We've gotten a draft settlement statement. If it's a finance transaction, clear to close. You're looking for the lender's clear to close. Now, I would suggest to you guys that you're looking for, bring some cash to the closing. I would suggest that you communicate with your lenders that you're looking for a clear to close at least 2 business days prior to closing. If you worked with our office before, you'll know that we start reaching out. First of all, when the file first comes in, we tell the lenders we require 2 business days prior to closing, because when that clear to close is given, I want you guys to know, you'll learn this when you take the clear to close. The closed and funded class. There's a lot that happens after the lender gives the clear to close. It's not, hey, clear to close, and you guys just show up with your champagne and your big key to take pictures. Like, no, that's just a domino effect of a whole bunch of steps that have to take place before we meet you at the closing table. So you want to communicate, stay in communication with your lenders. Make sure you're saying, hey, do we have a clear to close? We don't want to rush our buyers the day of closing to be making their wires at the last moment, right? With regards to your clients, you want to advise them not to schedule any vacations immediately before the closing date, because you never know what can happen, right? Specifically the buyers. Sellers, we're going to have the sellers pre-sign, as we call it anyway. As soon as title is clear, we prepare title documents. Your seller's signing a week, 2 weeks, sometimes 3 weeks even, depends, before closing. But the buyers specifically in a finance transaction, you want them to stick around, because so far I've only seen one lender that's doing a fully, electronic signing. So the buyers still need to make themselves available to sign. I would suggest that your buyers take the entire day off, or schedule at least 4 hours for closing. At least four, right? And you should tell them that as well. Tell your buyers to plan to wire their cash to close well before the scheduled closing time. I don't care how seasoned you are. If your buyer banks with a credit union, not just federal, a credit union, or if their cash to close is coming from an online savings, online bank, or some online savings account, those wires generally do not process quickly. They do not. So you want to have, you want to be in communication with your buyers and say, hey, we're coming up on closing. Check in with your bank to make sure that your cash to close is going to be delivered, the time period for it to be delivered to the closing agent. For you, send your disbursement authorizations and your wire instructions to the closing agent so that you can be paid at closing. Hopefully you can. I mean, that's we prefer. We prefer to pay everybody by a wire if we can. So if your office participates in providing you with disbursement, or DAs as they call it, get that over to the closing agent. Get that as soon as you know your final figures, as soon as you know what your commission is going to be, send it over, send them your wire instructions, and have your commission be wired to you. And if your broker is getting a portion of that, have theirs sent to them. Okay. Hannah's question: clients shouldn't wire cash to close until after the walkthrough. Not necessarily. If there's an issue at the walkthrough, they just won't show up. They just won't sign their closing documents to confirm that they're proceeding. All right. They should. So if that's what you're holding out for, but if it's just a timing thing, like, the walkthrough is at 9, closing is not till 3, so they should do their wire after the walkthrough, then that's that. But if you're concerned about the property condition, they can send their wire days before and still not proceed with the closing because of the property condition. All right. So the last concept, as we discuss this contract to close process, understanding that as a general matter, you guys will have an understanding of the fundamentals. You have a clear substantive understanding of the contract to close process, right? Once you get comfortable with that, but don't take forever to get comfortable with that. I mean this sincerely. Consider engaging a transaction coordinator. I hope you guys will see that outside of the substantive knowledge that you have about what should happen at each step, there's a lot of administrative tasks that are taking place in your contract to close process. There's a lot of follow-up, there's a lot of status update, there's a lot of following up for documents to be executed, passing information, and that's just simply not your highest and best use. It's not. A transaction coordinator will facilitate that for you while you stay in your zone of genius, which is either going after the next deal, the next listing appointment, buyer consultation, basically income generating activities. Once you're under contract, for all intents and purposes, that's old money. It's time to go get new money. A transaction coordinator, they vary. Generally, right now, I say you were looking at about $395 on the low end to about $495 per side, right? But here's the deal, and I say this all the time, and we're at the end, so I'm going to let you guys know. The beauty of working with transaction coordinators for you guys as realtors is that they generally do not get paid until you get paid. Now, some may have a small cancellation fee for their time, like $75 because they've taken time setting up a file. It takes a lot of time to set up a file. Our experienced agents will tell you, going under contract is a joyful thing, but it's also a heavy lift, right? Because you got to get it the title, you got to get all the intake done, you got to get everybody situated. Your transaction coordinator is even assisting with finalizing some of the inspection tasks, right? So again, once you get a good handle, and again, don't take too long with this, getting a good handle on this contract to close process, get a transaction coordinator. Because again, the paper pushing and administrative work is not your highest and best use. Yes, yes, Haley. And I know someone is going to make sure that you get a copy of it. The last thing I will say is we do have a transaction experts. I didn't put it up there. We literally have transaction experts. You're welcome. And that's going to be part of the training next month as well. The other thing that work with a transaction coordinator does for you guys is the level of service, right? How do you feel when you work with a title company and they're sending you status updates and they're keeping you in the loop, they're letting you know what's going on? When your loan officers are letting you know what's going on. At this point, guys, the name of the game is touches, right? The name of the game is touches. So you go under contract and you're telling your buyer, all right, we're under contract. Here's the next step. And you essentially can do the same thing for them. We're under contract, now what? For your sellers, we're under contract, now what? And again, as you learn today, the milestones don't change. Envision, how beautiful would it be for you to have a nice pre-printed, here's what you should expect at the escrow deposit stage. Here's what you should expect at inspection. Here's what you should expect with appraisal. Here's what you should expect at the loan approval phase. Here's what you should expect. I'm glad you're able to make it. Here's what you should expect with clear to close, right? So definitely awesome. Thank you so much. Definitely consider a transaction coordinator. I do believe the information regarding our transaction coordinator is in the handout that's going to be uploaded. But if not, well, as a matter of fact, we'll make sure it's in there. Jay, make sure it's in there. Any questions? Any questions? Any questions? All right. And feel free to come off mute if you feel like you don't type fast enough. I don't want you to feel like, I'm glad. I'm glad. I'm glad. I'm glad. I'm glad. I'm glad you found. Oh,
I
thank
had a
you.
quick question,
Yeah,
Raquel.
go ahead.
I wanted to ask you is, the time for acceptance, even though it says there that 2 days when you're counter offering, for
Uh-huh.
some reason, agents don't completely understand that. And then while you're negotiating, let's say you put the time of acceptance for tomorrow, okay,
Mm-hmm.
and we're going back and forth, but actually it gets accepted a day later. Now it still falls under the 2 days, but I've very often seen agents just want to put that particular day. They change the date even when they probably don't need to. Correct?
So if I understand you correctly, you're saying that you say super train. I try. Thank you, Victoria. Thanks for keeping us on schedule. If I understand you correctly, you're saying that the contract is accepted within the
When you
accept.
put a date in there for the time for acceptance, let's say when I write an offer,
You
I'm
said
giving
they put a
now
date in there?
2 days to accept the contract, right?
You can
Let's
put it.
say
Go ahead.
wrote the offer today,
Mm-hmm.
time for acceptance is September 16th.
Right.
Okay, but now we are going back and forth, and the after the language in there says your counter offer is within 2
2 days.
days. So
Yep.
what I'm saying is most agents don't clearly follow that 2 days. They don't look at that at all when
They
we're
don't know.
actually working it. And if we go beyond the 16th, let's say like it's 17th when everything's going to work out, I've seen, even if you're countering on 16th, you still have 2 days. You see
So
my
so here's the deal. If I understand what you're saying is that they don't get back to you within 2 days. Yeah.
no, no, that's not what I'm saying.
So what are you saying?
Yeah, I don't, what I'm saying is that for this time for acceptance, like let's say I wrote the offer today, I put 9/16 for acceptance of the offer. Okay.
Uh-huh.
On 16th morning, we're still good. I get a counter offer. I get a
Okay.
counter offer. It's the
Okay.
contract is not fully accepted. We're countering, we're negotiating.
Okay.
You see my point? So we're negotiating, and obviously this is going to go past the 16th. But if you see here, it says any counter offers shall be within 2 days after the day the counter offer is delivered. So even if on the 16th, which is my time for acceptance, we are countering on the 16th, we are going through some back and forth, and on 16th I countered or the seller countered, the buyer countered or the seller countered, we technically do have 2 days once this counter is delivered.
Right.
But
So
I've
now you have
seen
2 days
many,
from the 16th. Right. So if you count
right,
on
but
the 16th, you have 2 days from the 16th. Go ahead.
so, but what I'm saying is most agents don't even look at that 2 days, and we tend to just change the date from what we put initially, the 16th. We just kind of tend to change that date
So there's
and
so if
keep
again,
everyone on the same page.
no, 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 no. You make an offer, and I have on the screen now for everybody to follow what you're saying. So using your example, you said if not signed by buyer and seller, an executed copy delivered to all parties on or before, and you said 9/16, right?
Correct.
Okay. So let's say we made that offer on 9/14. The seller received it. They countered you on 9/16. They countered
Right.
you on 9/16.
Right.
Um, and so now there's 2 days from 9/16 to get your response.
Correct.
So what is your question?
My question is that I've often seen listing agents say, well, we've passed the deadline, and everybody just tends to change that date now to the 18th or the 19th, like actually strike out on this blank and change that to 18th because everyone just ignores the 2 days. They don't understand it, or you see what I'm saying is everybody wants to be very clear on, and then they just go ahead and change this date. But when you change this date, does it become like another counter, or I mean,
No,
no, it
no,
just
no.
what I'm saying is that the 2 days, I think everybody just ignores or they don't follow it or understand it.
Okay. Well, the thing is,
Technically,
what I would have a better way of, I hear what you're saying, but
right.
what would be a better,
Yeah, a better way of overcoming this would be good.
well, I wouldn't necessarily say overcoming it. What I would rather address is when you run into an issue, right? So for example, you make an offer using your hypothetical, you make an offer, the offer is to be accepted by 9/16. The seller counters you on 9/16, and then you go back to uh review it with
Buyer.
review it with your buyer, and you respond back to them on 9/17. They're like, oh, we already accepted someone else's offer. That's the conversation I would want to have with you, because you
Okay.
have a time period now. You gave me a 2-day time period to respond to your counter offer. Does that make sense?
Yes. So basically, like,
So I wouldn't frustrate myself with whether or not they understand that there's 2 days per se, versus only if it's going to affect me being able to get my offer accepted or not. Does that make sense? If they
yep,
get it, they get it. And if they don't, they don't.
right. Because if, let's say, the seller, while we are countering and the seller says, oh, he can withdraw his counter for sure, but if the agent says, no, 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 this, you went past your deadline. No, we did not, because we still had the
So
2
again, it's
days.
just a matter of them understanding how to
Right.
calculate deadlines. One slide I took out of here, and I should have included it, should have always included, is the number to the Florida Realtors attorney hotline. Just end all the confusion, end all the back and forth. Call them. They are sitting, waiting by the phones all day for your legal questions, right? So if you ever run into a specific issue regarding the contract, call them. Now, obviously, they're only going to give you, I tell you guys this all the time, they're only going to give you the black and white law. They're not going to issue spot and give you legal advice. They're not going to do that. You're not going to be able to give them necessarily a fact pattern and they say, well, this is what you should do. They'll say, this is what the contract says. This is the law. This is the seller's responsibility. This is the buyer's responsibility, right? So it will at least clear that out. So that's the last point I'll make. Instead of calling your friends, your colleagues, instead of even going to your broker first, I'm sure they'll appreciate you going to the Florida Realtors legal hotline and speaking with an attorney. Okay?
Okay, great. Thank you so much.
No
Appreciate it.
problem. Any other questions before we jump out of here? You guys have been super, super, super patient. All right. I will see you guys next Thursday on how to review the, what is the name of the Facebook? It is, go here. It's Expert University, www. All right. All right, guys. I will see everyone later.